Okay, right. Well, this is a very brief summary. A contract doesn't have to be in writing. The vast majority of contracts are oral, but it must have certain things. There always has to be an offer, not an invitation to treat, as what the law says, and there has to be an acceptance of that offer. Now, let me give you some examples. Whenever you go shopping, you enter into a contract. But when is that contract? If you go into a supermarket, you've got goods on shelves. The goods on shelves with price labels is what's called an invitation to treat. Just because you pick up an item doesn't mean you've entered into a contract. Where you will enter a contract is you've taken that item and you've gone to the tills, and you then endeavour and you pay for it, because you know when it goes to the tills, it's there with a price label. It's being offered to you. You accept that offer when you take it to the till and it goes through. And then one of the next thing is that it's important you pay a consideration for it. That is to say, the money, the cost. That's a simple contract that you just entered into. And we all do that every day of our lives. So there has to be an offer, as I said. There has to be an acceptance. That acceptance can be specific, that is to say, I accept your offer. It could be accepted by reference to conduct. So if you run a mail order business, for example, when you receive an order and then you dispatch the goods, you are in effect accepting that, accepting the offer. The acceptance has got to be unqualified insofar as if it was qualified, that is to say, I accept your offer if such and such and such and such, probably isn't an acceptance at all. What it actually is a counter offer that needs to be accepted by the other person, if you see what I mean. So there is a difference. So it needs to be unqualified. And I'm not going to go into in any sort of detail. This sort of touches also on what was referenced in the terms of business talk about the battle of the forms. So whoever has the standard terms that were used last tends to prevail as a broad rule of thumb, but not always. Both the offer and the acceptance must be communicated, which is logical, because obviously, how can you accept something if you don't know about the offer? Equally, if you're offering it, how can you know that it's been accepted unless you've been told of that? So there's got to be communication there. There also has to be certainty of the contract. So it's not going to be binding if it's too vague or it's not clear who's doing what and for how much. It could be incomplete in some way. And then lastly, there needs to be consideration. And the law is that consideration has got to be valuable. That is to say, it needs to be adequate. And that's in contrast to a consideration being either nominal or perhaps even gratuitous. If I just promise to do something for nothing, that's not a contract. That's just me just promising to do something. So very different. So in summary, that is what every contract involves. As I say, the vast majority are oral. It could be written. And there are exceptions which do need to be in writing. Contracts for the sale of land, for example, must be in writing under Law of Property Act 1925 and various legislation relating to that as well that followed. So yeah, they are the constituent parts. And that's why I say if I preface this by saying you entered into several contracts every day, you probably wouldn't have thought that right. But now I think armed with that information, you can see that. Is there an offer? Is there an acceptance? Have they been communicated? Is it certain what the contract is? And is there valuable consideration for that? And if all of those can be ticked, the likelihood is you've entered into a contract. Of course, this doesn't mean to say that there is always 100% clarity as to what that contract is. I mean, let's be honest, if there was, we lawyers would be out of business, wouldn't we? And there wouldn't be a raft of case law about contracts. But you know, they are the fundamental points. well, perhaps we'll come back to that when we just sort of mop up at the end. Changing the subject entirely now, and it sort of touches on the very first point when we were talking about mileage allowances. The fact of the matter is, when we all run our businesses these days, we are all 100% reliant on our driving licenses. Now, sometimes, I admit I was going to say through no fault of our own, but actually that's wrong. Through fault of our own, we can transgress the rules of the road and be guilty of speeding. I probably speed, I'm sure no one else is listening, every day. And I strongly suspect that if we all put hand on our heart, we all do to a greater or lesser extent. It's just that we've got to be careful about the greater extent. If that happens, then the consequences in the event that we lose our license are huge. So just in summary, let me tell you what those consequences and the procedures actually are if we find ourselves someday in that precarious position. First things first, the likelihood is you'll be caught by reference to a camera, whether it be fixed or movable. If it's a camera, then of course it's going to work on number plate recognition to the extent that you will then receive what's called a section 172 notice out of the blue, asking you to, what it'll say to you, you are the registered keeper of the vehicle. Between this date, between this time and on this date, it was identified as speeding in this location. You are required to identify who was driving on that occasion. More often than not, it's probably you, but it might not be. And do be aware about of also the issue about cars that are owned by hire purchase companies or lease companies or something or other before they become your property. You are obliged to fill that document in. If you don't, it's an offence, and actually that will give you at least as many points, if not more sometimes, than the actual substantive thing. So always do that. If you send it off, they will then process it, and it depends what the speeds are. If it's not that much over the limit, whatever it may be, you could be afforded a driver awareness course if you perhaps haven't done one in the last, I forget if it's 2 years or 3 years. I have done one of those, and if you enter into those with the right spirit, they are very informing. You learn an awful lot. So I urge you to opt for that if you do, for two reasons. One, it'll probably make you a better driver. And two, it keeps any points and fines off your driving record. And you have to pay for the course, but it's £100 or thereabouts. It's not the end of the world. If, however, you transgress again within the relevant period and are not afforded a driver awareness course, or your speed is such that it was too great, then it is entirely possible that you may find yourself facing a summons. If the summons requires you to attend court, you will be afforded the opportunity of pleading guilty by post, if that's what you want, by filling in a form. And I'm assuming that everybody is guilty, because almost invariably they are. And just a word, I'll mention a word about the contrary otherwise. But if you do, then speeding is not an offence that is punishable by anything other than fine, but the fine is based on your ability to pay and can be substantial. But much more importantly, it carries between 3 and 9 penalty points, depending on how great your speeding is. And there is a matrix that the magistrates have which will allow for that. Indeed, you can even be disqualified on a discretionary basis, but that's rarely exercised. What is exercised, however, and is the ability to disqualify if by any chance you've already, your penalty points means that you now have 12 points or more on your driving license, and you are liable for disqualification under the totting up procedures. You can argue either special reasons against disqualifying for the offence. That's unlikely in the case of speeding. Much more importantly, mitigating circumstances as to why your particular circumstances are such that it would be unreasonable to disqualify you, even if though you have got more than 12 points. Usually, experience tells me that that's because it would cause exceptional hardship to someone other than yourself. Simply losing a job or not being able to pay a mortgage or something like that usually isn't going to be enough. It'll need to be a little bit, you need to concentrate your focus as to where it would be. And I strongly urge, if you need to argue that, then you probably do need to consult with a lawyer, because they will be able to marshal those arguments better than you can. I would also say that if it's going to be anything other than a relatively small amount over the fine, it's generally worthwhile biting the bullet and going to court and pleading your case in court, because it shows a degree of responsibility being accepted. If it's only a relatively minor infringement, but nevertheless you're before a court, yes, you can plead guilty by post, but expect the court simply to give you exactly what the sentencing guidelines say, because that's almost certainly where they are going to be, and you probably aren't going to get it varied from there. So that's pretty well what the consequences are and what the procedure is. I did say I would mention just in passing what happens if you don't wish to plead guilty. You can do that, but you are basically going to have to show that the recording equipment that recorded you was wrong. That is an extremely difficult thing to do and very expensive. You're going to need experts. You are definitely going to need specialist lawyers to do that on your behalf. And that will be, I wouldn't fancy taking that on. For example, that is something that very few people would be willing to do and likely to succeed with. So just be aware of that. You're going to need a Mr. Loophole type character. And I have to say, I once was actually consulted by a former client of Nick Freeman, who told me that he couldn't even get an appointment without paying him £10,000 on account. He couldn't even get the appointment without that. And that was many years ago. What on earth he's charging now, I have no idea. But anyway, so there we are. Right,
David,
that gives you food for thought.
If going to court in order to plead guilty, but with the expectation of getting some mitigation, is that something that an individual should do in their own right, or should they not consider doing it without a representative?
I would say that more often than not, provided they know what their mitigation is, you will find that they will be able to do just as good a job as a lawyer can. They are not going to be eligible for assistance from the court duty solicitor because the offence isn't imprisonable. You don't risk anything by doing it yourself, and it's highly unlikely. The courts are not such that they will penalise you by saying the wrong thing to increase the fine, shall we say. Mitigation is all about why you should get paid less than the going rate, or why you should have to pay less than the going rate. And there may be circumstances, and just mitigation along those lines can be the problems it's going to cause me and my family in relation to my business. Exceptional hardship might be where you're arguing that it's the problems that it's going to cause to your clients. So third parties, subtly different. And one will carry much more sway than the other.
David, how can certain people keep offending and not get punished? I'm thinking of Katie Price, who keeps getting picked up for speeding and drinks and drugs, and she's still out of prison. And where I think most of us, if we were caught, God forbid, ever drink driving, they'd throw away the key.
You'd be surprised. I don't know anything about her particular case, but I believe I read just recently that she'd been caught drink driving again. And I say again because I think it referenced the fact that she had previous convictions for it. Drink driving is actually imprisonable. So it depends on the circumstances, and it depends on the ability of her lawyer, which no doubt was very expensive.
Yeah.
And what arguments were put to the court. But yes, she could have been sent to prison. And certainly when I was doing a lot of criminal law at Southampton, there are serial chances, shall we say, that will do that. And people are sent to prison. No, there's no question about it. They are sent. Repeat offenders are sent to prison. And they're also sent to prison if the extent of the intoxication is very substantial. And you would be surprised sometimes at the levels at which people exceed the drink drive limit, to the extent that you wonder how they were able to get in the car at all, let alone drive it. Seriously, I mean, 3 times the limit, not unheard of.
Yeah.
That's 300% over what the law says. So that's we're talking about serious amounts here. But yeah, they can result in imprisonment. Very often, of course, the imprisonment will also follow because of the consequences of that drink driving. So accidents and the like that may be caused. But yes, some people just are fortunate. Does anyone have anything else that they want to ask, or any other searching questions? Or have we?
Yeah, hoping we won't get nicked.
Well, I hope not too. But it can happen. I'd be the first to say that I've certainly had a fixed penalty in the past, and my dear lady wife has had a traffic light offence where the thing jolly well had just turned red, just as it, or turned amber, I think it was, just as she was going through it, or so she said. So those sort of things can happen. Happily, I have to say, we've got clean licenses, both of us, at the current time. But but for the grace of God, do we all go? And when you consider the amount of miles we've driven, probably over our lifetimes, it's perhaps not surprising that every now and again the cards won't be stacked in our favour.
Yeah.
If employing someone, David, I mean, if looking at employing someone, so you have a candidate come along who, I don't know, are you even allowed to ask them what the state of their driving licence is? Yes, you probably are. Are you allowed to discriminate against somebody because you think if he does it once more, he's going to lose his licence and not be able to do his job?
Probably not. But where I think that you're certainly entitled to, if having a valid driving licence is a condition of their employment, which it is for many, it is probably important that you actually have sight of their driving licence as well. Yes, that's going to be necessary, probably because you may be actually arranging insurance, for example.
Yeah.
You may also have other considerations. Now, just as an aside, we as a practice have a van, and it's used by, well, we don't have it at the moment, but we have in the past employed, shall we say, an odd job man that would go around moving files between offices, doing the odd, change light bulbs, doing the odd little DIY bit that needed doing in our suite of offices from time to time, that sort of thing. We had one particular individual who kept turning up smelling of booze. We had grave concerns about his drink driving, or whether he was drink driving at all, and the damage that would do to our reputation in the event that he got caught driving a sign-written van. And we actually bought ourselves a testing kit, and we demanded that he test himself. And I can't. It was a while ago now. I believe he did test. I believe he did test positive, but I think, if I remember rightly, he used some sort of argument about how he hadn't been driving at the time, or something like that. Anyway, the long and the short of it is, he wasn't employed for much longer after that. I believe he left, probably recognising his number was up, but sadly, not that long after, he died. And I believe it was connected with alcohol that caused his death. So yeah, all of these things, reputational damage is important as far as that's concerned when we run businesses. So yeah.
Very good.
Anyway, I think that probably, well, my computer says it's 2 minutes past 5, and I know how hung up Matthew gets if I'm 2 minutes over. So I suppose without further ado, does anyone have any final wind-up points?
No, it's been really interesting.
No.
Really good to talk to
Good.
you.
Good. I'm